Well, hello everyone, and welcome to Uncivil Law. I hope you're having a great day, and wherever you are, you have power. I'm happy to say that even though I am deep in the heart of Texas, I have power, so I feel very lucky, and we are here with some more stuff from Toddy without a crystal ball, or really what we should be just calling the Brown Salts Show, because, yeah, that's what we're doing now. So we have a motion from Brown to expedite Rule 11 sanctions. So let me give you some background to remind you about what all that means. So Brown and I suppose Katie Joy are suing. Well, suing isn't right word. They are seeking sanctions. That's better. Under the various rules for filings by Salts. So Salts filed. So what they're seeking damages for is the declaration from Lorianne Barnhart. The basic premise of this motion is that Salt knew or should have known the declaration from Lorianne Barnhart was false or was unreliable, and that he did not do his due diligence to make sure that it was proper and fair. And we have taken a look at the various things that we have on offer. We still don't know what Michael Brown knew. We know what Brown knows, but we don't know what we don't know what Salts knew. Because we had the pleasure, and I use that word loosely, of reading many different exchanges on email from Brown, between Brown and Lorianne, at the time when Lorianne was talking to Brown. So Lorianne was talking to Brown, and she wrote, among other things, this 2,000-word missive, basically saying, here's the story, which is a perfectly reasonable thing to do. It's like, here's the story. And the story is basically, I'm not that close with Katie, and among other things, right? So there's just a lot of stuff there that was helpful to Brown. Brown started to write some proposed declarations that Lorianne would sign. Lorianne seemed cooperative and willing to sign those. She gave some notes back, but she wasn't fundamentally objecting. So it seemed like it reflected what she thought, and based on our own reading of the declarations and based on our own reading of the emails, it seemed to be in keeping. So I didn't have any particular problem with what Brown was doing personally. And then for some reason that's a little bit vague and unclear, Lorianne switched sides. That might be because Katie Joyce threw her under the bus and said, I never knew you, which incidentally was what Lorianne was saying at that point. So I don't know, not a friend at all, but, at that point, what Katie was saying and what Lorianne were saying were pretty close. I mean, Katie was being a bit more aggressive about it with I've never known you at all. You've never been my friend at all, which is a little bit harsh. But if you go read the 2,000 words that Lorianne wrote to Brown, that's kind of the same thing, sort of. It's like, yeah, we weren't friends, we weren't close, we didn't hang out, we weren't besties. So so here's a couple different possibilities. Number one, she was lying to Brown and she got thrown under the bus, and so she switched sides. But then, of course, if she was lying to Brown, we have to consider the very strong possibility she's lying to Salts, right? Because she's not a reliable witness. So if she was making up falsehoods to that degree to Brown, one can only imagine what falsehoods she might be making up to Salts. Or maybe it was true, and she's just completely lying to Salts. I don't know. But it didn't seem like Brown was coercing her or putting pressure on her. Everything, it looked okay to me, based on what Brown was doing. Now, we could get into quibbles, and we could get into the deep weeds of, was Brown representing her? Maybe. Was there a conflict? Not that I even saw. So maybe Brown was representing her, maybe not. But I didn't even see a conflict of interest at the time between Toddy and Lorianne. Because what Lorianne was saying on her own initiative, again, because she wrote this 2,000-word missive without even being asked, she wrote it. She wrote these 2,000-word missive, and what she said was extremely compatible with Toddy's legal interests. So I'm not sure Brown was ever representing Lorianne, and even if he was, in my humble opinion, there was no conflict of interest. So maybe he should have done more. Maybe he should have been clearer about whether or not he was representing her or not. Maybe he should have been clearer on, the nature of any potential conflict of interest. So we could quibble. We don't have to think that Brown did everything perfectly. I'm not saying we have to say that. So maybe he should have been clearer. Maybe he should have been, he should have been clearer about potential conflicts or likely conflicts or something like that or whatever. But, at least to my humble opinion, beyond the technical aspects of the concerns about conflicts of interest, what Brown seemed to do was perfectly proper for the rest of it. I didn't have a particular problem with it in my humble judgment. So it might be that she was lying to Brown to make Katie look good, and then having been stabbed by Katie, she switched sides and told Saltz the truth. Maybe that's what happened. Or it might be, as Brown seems to think it is, that Saltz was putting undue pressure on her, or at least Lori Ann perceived undue pressure on her. And so she flipped sides in order to make the pain stop. And she did it out of expediency, which is sort of understandable, but then again raises the question of maybe she's just saying something to make the pain stop, right? It's like when you put enough pressure on someone, they'll say anything, to make the issue stop. So Lori Ann is, in my humble opinion, not a credible witness at this point. I don't think we can determine what is true and what's not, because the most likely thing to be true would have to be what she told told Brown initially. I say that because it's the thing that's said earliest. It was completely unsolicited, and it's written completely in her own words, like 2,000 words of it. So, of all the things that are most likely to be true, in my humble opinion, the most likely thing to be true is what she told Brown initially. Now, maybe that's not true. Maybe she was lying to make Katie look good. Maybe she was telling Brown what she thought would be good for Katie. So, but even if it's so I think it's the most likely thing to be true. And even if it's not, if it's a lie, then in my humble opinion, we can no longer credit Lori Ann as a witness in this case. She is unreliable. So that's what I think about that. So anyways, so at some point, for whatever reason, Lori Ann goes over to Saltz. And Saltz winds up filing a declaration that looks substantially different than the one that Brown prepared. Now, the question is, what did Saltz know, and when did he know it? And what diligence did he do at what point? And since we know that Lori Ann is an unreliable witness, we can be at least skeptical, and I think rightly so, that Lori Ann gave Saltz everything that she had given Brown. We don't know what she gave Saltz. We don't know what she said, and we don't know what Saltz knew. So if Saltz knew everything that Brown knew, then what he did looks suspect at best. Because how can he... I mean, you could at least hypothetically imagine some scenario where what Saltz did is okay, because somehow he was utterly convinced that she had lied to Brown and she was really telling the truth now. Maybe you could get there, but if Saltz knew everything Brown knew, then following that declaration does become a question mark in our mind, where our attention gets raised and like, what's this now? Because it seems a little odd. So more likely, and I think it is more likely, because again, we're basing probabilities here on what we know little about these people. I think it is more likely that Lori Ann didn't give Saltz everything. And Brown went and did something very quick, and maybe he's getting burned by that a little bit. It seems possible. It even seems more likely than not. Now, I also have to admit my biases here, because I want to assume my fellow practitioners are acting in good faith, so I want to give them the benefit of the doubt. So that's my bias, right? So I look at this, I'm like, is it more likely or Saltz or Brown are acting properly or not properly? I'm like, it's more likely they're acting properly, but that comes from a place of bias. I want to believe in the best of my profession. So, take that for what it's worth. But I'm willing to give Saltz the benefit of the doubt. Brown, however, is not willing to give Saltz the benefit of the doubt. So Brown is going to the edge of the earth very aggressively in a way that I find to be a bit distasteful, personally, because he's assuming the absolute worst case scenario. Everything Brown says could be true, but it's the worst case scenario. And I don't know why we're leaping straight to the edge of the page. So anywho, he filed a motion earlier for sanctions under the under 28 U.S.C. 1927 and under the court's inherent authority. And he had a footnote in that where he said at some later point, I'm going to file a motion under Rule 11, which is the typical one that you see, Federal Rule Civil Procedure Rule 11. And now he's filed a motion to expedite his filing of that because there is a safe harbor date in the rule. He can't file it for 21 days. So he's asking the court for permission to file it sooner. I don't know, man. I don't know about any of that. Seems So we're going to read this motion, then we'll read Rule 11, and we'll discuss a little bit more about what sanctions are for and what they're not, and all that good stuff. So here's the motion on our favorite 48-line paper, so, deal with all that. This is the motion to shorten the time for Rule 11 sanctions. Okay. So what is going on now? Nate the lawyer said, I thought this was a motion to dismiss. That was in the long, long ago in the far, far away, man. The motion to dismiss is something that has left our minds. Yeah, that was in the long, long ago in the far, far away. All right, motion for Rule 11 sanctions against plaintiff and their counsel. This motion will be based on the same conduct that forms the basis for the motion for sanctions pursuant to 28 U.S.C. 1927 and the court's inherent power. And then they note here that the docket is for the Laurie Ann Barnhart Declaration. They say the declaration procured and drafted is replete with demonstrable falsities. Well, they're demonstrable to Brown. I'm not sure if they're demonstrable to Saltz because we don't know what Saltz knows. Rule 11 provides a motion. Well, I don't even know if they're demonstrably false. They're demonstrably extremely suspect and unreliable. That's unambiguously true. So what is true and what's false, we don't know. Is it reliable either way? No. It is unreliable and should be discounted in this humble jurist's opinion. Rule 11 provides that a motion for sanctions brought thereupon generally must not be filed or presented with the court if the challenge paper, claim, defense, contention, or denial is withdrawn or appropriately corrected within 21 days of service or within another time the court sets. So, under the standard rule, you get 21 days to cure. And I'd like it to be faster now. Okay. However, the rule contemplates a situation in which it may be difficult or impossible to comply with the 21-day provision. Defendants submit that may be the situation here. Currently pending before the court is defendant's motion to dismiss. The focus of that motion is defendant's challenge to assertion of personal jurisdiction over them. Is it though? Is it though? I mean, seriously. Is the focus anywhere even remotely close to personal jurisdiction at this point? I don't know. I'm going to go fact check untrue on this one. Fact check untrue. The focus is decidedly not on jurisdiction in any sense that I understand the word focus. Should the court grant defendant's motion and dismissal the lawsuit with prejudice on personal jurisdiction grounds before the expiration of the 21 days, this court will lose jurisdiction to consider the motion, which the court's probably like, yay. Defendants admit that this result would be inequitable in that it would insulate plaintiffs and their counsel for responsibility for what defendants believe are clear, demonstrable violations of the rule. Really? Why are we going to the worst possible interpretation? I wouldn't know, again, because I don't watch Katie Joy, because I want to remain as unbiased as possible. But it has been suggested to me that Katie Joy sometimes takes a more negative interpretation of things. And I wonder if Brown is being influenced by that at all, because this is plausible. It's just a very negative interpretation of reality. So, They respectfully request the court shorten the 21-day waiting period to 8 days from the day of this filing. That is February the 23rd. Okay. Defendants have sent their draft motion to counsel on the day of filing and also serve it by mail on the 16th. Good. That'd be today. The parties conferring regarding this motion to shorten the time, they conferred to shorten the time. If they conferred, why can't the conferral be also, here's what I knew or what I didn't know? Does Saltz not want to clear this up, or is Brown not hearing it? Or is there nothing to clear up? I don't know. And signed, and that's the end of it. So it's just a motion to expedite. So nothing super sexy there in terms of the content, but he wants this to be heard right away, lest the court lose power to sanction Saltz for his demonstrably false, or no, not even that, demonstrably violating of Rule 11 conduct. Now, he doesn't really say at any point how it's demonstrably provable that Saltz did that. Because unless Brown knows more than we do, which is totally possible, maybe he does know more. Because, he's in the thick of it. So maybe he knows something we don't know. But unless he knows something we don't know, how is he demonstrably showing that Salt violated the rule? Because how does he know what Saltz knows? I don't know. It is a little bit vague to me. So I thought as long as we're here and we could learn something else of value, I thought maybe we could discuss Rule 11 and what it is. Now, I probably should have made a PDF of this in advance, which I didn't do, so that I could share it with you so I can read it with you on screen. Let's see if I can do that in a way that will make any sense. Yes, I can. Great. So I can save this. And so, yeah, save that there. Great. Fantastic. And then I can open it. We can actually read the rule together. How fun. All right, great. Now I just switch that. Okay. So this is Federal Rules of Civil Procedure, rule number 11, which is the one that deals with sanctions. So this is the one that no attorney wants to hear, the Rule 11 sanctions. So I thought we could just read the rule together. So, yeah. So here is what it says. All right. Every pleading, written motion, and other paper must be signed by at least one attorney of record. All right. Representations to the court. By representing to the court a pleading, written motion, or paper, whether by signing, filing, submitting, or later advocating it, an attorney or unrepresented party certifies that the best of the person's knowledge, information, and belief, formed after inquiry reasonable under the circumstances. Okay, so basically it's saying, okay, when you're submitting something to a court, that's kind of an official thing, right? It's you're submitting something to the government for them to adjudicate on. And you are making certain representations when you file things before court. And this is particularly true if you're an attorney, because you're an officer of the court. So, although the rule is written to also allow this against private parties, I can't think of a time when I've ever seen it used against a private party. But for an attorney, sure. Because attorneys are officers of the court, and they're really supposed to know better. Also, as a general rule, courts will bend over backwards for pro ses until they get really irritated with them. So, okay, what are you trying to certify? Here's the things that you're certifying by putting, if you like it, you should put a ring on it. And when, in this case, the ring is a signature, and here's what you're buying for your signature. You are representing. It's not being presented for any improper purpose, such as to harass, cause unnecessary delay, or needlessly increase the cost of litigation, which is also reflected in 28 U.S.C. 1927. And then 1927, which I won't put on screen right now, says, any attorney or other person admitted to conduct a case, so this only applies to attorney, who so multiplies the proceeding in any case unreasonably and vexatiously may be required by the court to satisfy costs. So if you're in violation of this rule, then 28 U.S.C. 1927 turns around and says, you can get cost damages for this. So that's one of your remedies that you have if you are filing things for the purpose of harassing or causing delay or needlessly increasing. So if you're merely filing things to make things more burdensome for no other purpose, you can't do that. Here's what else you're certifying: that the claims, defenses, and other legal contentions are warranted by either existing law or by a non-frivolous argument for extending, modifying, or reversing existing law for establishing new law. So this one is pretty interesting. And actually, you can't get money damages for this one by rule, which is pretty interesting. But yeah, you as an attorney have to make claims, defenses, and arguments that are either A, warranted by the law as it is, or you have to make a case for why the law should change, which you can absolutely do. You can absolutely do it even if you have direct on-point authority. Now, you better have something pretty good, especially if like that's from a court of appeals or the U.S. Supreme Court. So, if you're going into court, you're going into your trial court, and you're like, I know I have this Supreme Court case which speaks directly against me, but here's why you should do it. First of all, you need to admit it, that you have it directly against you. So if we turn to, for example, the case dealing with the draft, where that group was suing to get women to be in the draft, right? They had a case that was directly on point against them from the U.S. Supreme Court. Doesn't get much better than that. There's a direct case from the U.S. Supreme Court that says quite clearly that the male draft is fine and not having female in the draft is fine. And there's another case that says that even if the factual underpinning has been undermined, the legal conclusion remains. So for that case, for example, in the draft case, the factual underpinning for why the Supreme Court made that decision had been eroded. I think that much is fine. But there's another case that says even if that's true, it's still good precedent. So if you have that kind of situation, whether that's Supreme Court, Court of Appeals, or otherwise, you have to steer straight into the skid. And that was one of the things that they screwed up big time. They didn't do that. They were trying to hide the ball, and it didn't help them. You have to go straight in and say, I have this case, which speaks directly against everything I'm saying. But here's why this case should be modified, extended, revised, thrown out. It should be overturned, and blah, 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 and all the rest of it. And you have to have some pretty good reasons, particularly, again, if you're going to be challenging the U.S. Supreme Court. I'd like to challenge the U.S. Supreme Court now, trial judge. Here are my pretty good reasons. They better be pretty good. So, yeah, you can do that. You just have to, have a good faith basis for why you're trying to do that. And also admit that you're trying to do that. And not hide the ball. So, yeah, that's what that rule says. All right, number 3. The factual contentions have evidentiary support, or, if specifically so identified, will likely have evidentiary support after reasonable opportunity for further investigation or discovery. And this is like, what does that mean exactly in this context? Because Saltz acted so fast. Was he under an obligation, or did he feel like he needed to act that fast? And so, what is a reasonable opportunity to investigate in this context could be a questionable decision. And then number 4, the denials of factual contentions are warranted on evidence or are reasonably based on lack of or belief or lack of information. So if you deny the facts, it's because you think the facts are not that way. So this is all a very, very fancy way. This is all a very, very fancy way of saying you have to actually believe what you're saying. And you can't just make shit up because it would be nice. You can't just deny reality for the hell of it. You can deny the facts because you think they're wrong. You can deny the law because you think it's wrong. You just have to, be clear about that you're what you're doing and all the rest of it. And you can't lie. And you can't make up shit. And you can't submit facts that you know or should know are false. So that's basically what Brown is saying that Saltz did with the Lorien Declaration. That he knew or should have known that it was false, because if he had used his reasonable opportunity to investigate, he would have clearly determined it was false and he wouldn't have filed it. Now, all that being said, I'm going to give you my answer, which may again be biased, because I want the best out of my fellow attorneys. So I would not be too upset if someone disagreed with me. But for my money, this doesn't even come close, in my humble opinion, to sanctionable conduct. Unless Saltz now being... The only way it would become sanctionable at this point is if Saltz, now having the information, because now Saltz has it, if Saltz continues to double down unless he thinks that there's some other reason that he's right. So if Saltz doubles down for the hell of it, that's bad. If he doubles down because, he had a moment of connection with Lorianne and he really believes it, then maybe. But either way, I don't think we're up to sanctionable conduct at this point. Not to say it might not become sanctionable later, but I don't think we're there. And besides, if we're going to sanction people for things, I want to sanction everyone for just, filing crap. And then my remedy as the court is basically ignoring all of it. They're just going to ignore it. So that's my sanction. This is all stupid. Here's the sanction. I'm ignoring everything. So yeah, that's basically where we are and all that. So Will the court grant this? No. No. Why would they? Unless the court just wants to be done with it first. I wouldn't be half surprised if the court files a minute order just saying motion denied. The motion for sanctions is denied. I wouldn't be half surprised that the court issues an order just saying the motion for sanctions denied without having a response from SALTs. It's just wrong on its own terms, and so we don't have to even consider it. That could definitely happen. Do I think the court will expedite it? Not particularly, because I think the court has better things to do with their time. Unless they just want to sanction it, unless they want to expedite it because they want to whack everyone around again. So maybe that, but otherwise, no. So that's what I think about all that. And as we've pointed out, we've long since forgotten anything dealing with jurisdiction. Jurisdiction is but a distant memory that is long gone in our minds. And we're like, the jurisdiction, and it doesn't even matter. Can the judge ignore it completely? Yes. It's good to be judge. Yeah. The judge can ignore lots of stuff. Yeah, because it's discretion of the judge. So the only way that they can't do that is if it's abuse of discretion. And abuse of discretion is a pretty big trigger. It's hard. So can the judge just ignore the last 20 filings? Yep. Yeah, it's like, none of this is relevant to anything. I'm just going to ignore it. It's good to be judge. You're literally the judge. I'm going to say, I'm not paying attention to any of this crap because I don't care. Since Brown is a Washington attorney, will that hold any weight in this court? It doesn't matter either way. Whether they're either admitted to the court full stop or they're admitted pro hoc vice. Either way, they're within the court's authority. So it doesn't really matter either way. It's like once you're before the court's authority, you're before the court's authority. If Saltz wanted to be a D, could he now file contempt against Katie for deleting her entire Twitter after the judge motion to preserve was signed by the judge? It depends. It depends whether or not it was preserved despite the deletion. Preserving it doesn't necessarily mean that the account has to be stayed up. So if it was archived in some way, then Katie wouldn't be in violation of the order. It would. So it depends what else happened. So she has a duty to preserve the evidence, but it doesn't necessarily have to be preserved on Twitter. So if she was preserving it some other way, then that might be fine. I really don't find Saltz to be an amateur. No, I don't find them either. I don't find either one of them to be an amateur. But everyone makes mistakes. And he did file very quickly after Lorianne contacted him. And, I'm not saying he's an amateur. I'm saying that everyone can make a mistake. And maybe he let something get by him that he shouldn't have. And, we can at least entertain the possibility that he did not know what he didn't know. And maybe that's what's going on. So I'm not saying he's amateur. I'm saying everyone makes mistakes, and maybe he made a mistake. I'm willing to give him some credit. That sounds corrupt that the judge can do anything. I mean, they literally tell it to the judge. And the judge can be like, The judge does not have to pay attention to your inane ramblings. Just because you are before a judge doesn't mean that you can say anything and do anything. And if you're talking crap, the judge does not have to listen to you. So, I don't know what to tell you. Why didn't I become a Why did I become a judge? I've never had the opportunity before. I used to live in Virginia, and Virginia is by appointment. And to be appointed as judge, you have to be buddy-buddy with a politician. And I'm just not buddy-buddy with a politician. So I never had the opportunity. Now I live in Texas and I could run for judge, I might consider it. But I've never had the opportunity. And obviously I've never gotten a call from the president. So I think being judge would be cool. I'd like to be judge. So, someone call me. Let me know if I can be judge. Someone call Biden. And let him know I'm available. There are a lot of openings, incidentally, that just happened. There's a lot of judges now going into senior status. So there are quite a few openings at the moment. So I'd be more than happy. Just saying, I'm available. Emmeline says, I'm tired of you defending KJ since no one's going to say it. I don't personally see it that way. I don't think I'm defending. First of all, I'm at this particular moment, I haven't even really talked about KJ. I'm talking about Brown. So at this point, I'm defending Brown, not KJ, and they are different people. Second of all, I think I'm giving everyone fair. I think I'm being equally fair to everybody. And I don't know anything about KJ, nor do I particularly want to. I'm trying to do a legal analysis over here. And so if I'm rendering legal opinions, like I think Katie has some really good arguments on defamation, and I think Katie might be able to win this, that isn't because I'm biased towards Katie. It's just because, given the information that's currently available to me, it's my best informed legal opinion. And that opinion might change as things progress, but I'm giving you my opinion at every given moment. And as things change, I'll revise my opinion, as one does. But this is my current opinion, for whatever value it has. But I don't see myself as defending KJ. Or if I am, I think I'm being fair to both sides. I mean, I don't know her, I don't know what he is. Yeah, I think I'm being fair. Are you a bit conservative and want an appointment from Biden? No. I don't really care if Biden gives me an appointment. I'd be thrilled if Biden gave me an appointment. Am I too conservative to want an appointment from Biden? No. That would in absolutely no sense influence my judging, incidentally. But do I care if Biden appoints me? Absolutely not. Amanda says, I think you like to hear both sides. I don't think you're biased. I'd rather hear your opinion than popular opinion. Yeah. I'm just trying to look at the law. And looking at Katie as a bad person is not helpful towards that exercise. It's entirely possible to think that Katie is morally wrong and legally correct. Yeah, that could be. Can KJ complain to someone about the judge? Yeah, the Court of Appeals. Good luck. Good luck, because the standard is abuse of discretion. That's a hard trigger to pull. That is a hard trigger to pull. Yeah, she could complain to the Court of Appeals. Good luck. Sometimes I'm sassy and I think you need to be more chill about the lawyer's actions. I don't know. I'm just responding the way that I don't know. Purple Cove had a good question. How can Brown keep asking a judge to make decisions before jurisdiction is decided without basically giving the court jurisdiction? Okay, well, that one is easy. The reason that Brown can ask the court to do stuff is because they're asking them to do stuff with respect to salts. The court has jurisdiction over Brown and salts. They're officers before the court. So, do they have jurisdiction to decide the issues involved in the Katie case? Don't know. Does the court have jurisdiction over Salts and Brown? Hell yes. Hell yes. So the reason that Brown can ask the court to issue sanctions against Salts is because Salts is an officer before the court. The court sure as hell has jurisdiction over him. Yep, that's easy. That's easy. How much does a Court of Appeals cost? Lots. I don't think she's crazy enough to do that. I didn't say it would be a good idea. I was just answering, here's who you could complain to. And I also said good luck, which is a way of saying you're going to lose. I know she'd lose. I can do the analysis in my head. This isn't even close to abuse of discretion. The judge is like, yeah, I'm here to decide jurisdiction, so I'm basically ignoring all this crap because it's not that. That isn't even close to abuse of discretion. Has Salt's responded? No, not yet. We haven't seen that. And so Salt's response will be very, very interesting because Salt's will hopefully give us some information about what he did know or didn't know. So Salt's will presumably say one of two things. Either one, I didn't have the information at the time, or two, I did, but I also had some other information that made me think that this was tenable. And we'll evaluate it from there. Your Texas, you have to say, bless his heart instead of good luck. Bless your heart is like the ultimate insult. That's a way of that's a really insulting thing. The way it's like when someone says bless your heart, I'm like, oh my God, that person just got torn down. Bless your heart is one hell of an insult, man. And it comes like it sounds nice, but man, geez, Lord, is it possible the very next things we'll hear on the ruling is jurisdiction? Yeah, the most likely thing to happen in this case would be the court deciding jurisdiction. Unfortunately, that has been the most likely thing to happen for quite a while now. So we've seen how well that's gone. So if you're asking me what is the most likely thing to happen, a decision on jurisdiction. Unfortunately, that's been true for, I don't know, 25 documents or something. So, yeah. To the sassy comment, I'm 100% speaking for myself. Yeah. Have you read the transcript of the meeting? Yes, I have. I mean, there's not a formal transcript, but I've read the informal versions. The judge worded something, in my opinion, where she said counsels and parties, be leaning like she's leaning towards jurisdiction. I didn't really see it. that way. Again, the judge has jurisdiction over themselves. The judge has jurisdictions over the things that's happening in their court. And so they can give directions as long as it's there. So that doesn't really speak to jurisdiction in my view. So I didn't really take it as a tee off. I saw it as like, yeah, I can order you guys around because for whatever reason you're here for the moment. So for however long that moment is, I can control what happens in my own court. So, I mean, think about this a different way. Let's suppose that this was happening in the real world, or it used to happen in the real world where we actually, met in person. So suppose this is happening in the real world and they're in a courtroom and Toddy and Katie's in a courtroom with them, which is not unheard of. And let's suppose that Katie just starts getting up and ranting, whatever. Do you think the court can sanction them, even if they don't have jurisdiction over the case? The answer would be yes, right? You're in contempt. So yeah, if they're there to fight about jurisdiction, the judge can simultaneously say, I don't have jurisdiction over this case, but because you're acting like a complete ass, I can sanction you for your being a complete ass. So I don't have jurisdiction over the case. I do have jurisdiction to sanction you for your conduct. So you're in contempt now. Yeah. So even if the judge doesn't have jurisdiction over the case, they have jurisdiction over the people involved for as long as it lasts. No problem. No problem. I don't have that's a really strange result. Can you just imagine? It's like, I don't have jurisdiction over this case, so I can't do anything about the person ranting and raving. I mean, it could be rando audience member. Rando audience. It could be you. It could be you. You're just there. You're just there one day, listening to this hearing in person. And you decide it'd be a really good idea to stand up and say, this is a whole bunch of bullshit. This court is full of bullshit. Fuck this court. So you haven't filed any papers. Do you think the court has jurisdiction to sanction you? I do. Yeah. The court has jurisdiction over itself. So, yeah. Someone here thinks I'm in the tank for Katie. I'm really not. I'm just giving my best legal answer based on my legal information, right? I've taken a look at the case and I've tried to generate possibilities in my mind, like who has the better end of the argument, and I'm trying to generate a perfect case, right? So at least in my own mind, I'm trying to generate a perfect case, which this is not. So how this will turn out in the real world is very distinctly different from what I think the hypothetical perfect case would look like. So we haven't really given odds of winning yet, because we're not there. So we haven't really given odds of winning the ultimate issue. I think in terms of jurisdiction, we're about 65-35 for Toddy. That's about my best guess. So it wouldn't surprise me either way, but yeah, I think I'm leaning towards jurisdiction. That's my lean. We haven't estimated the probability of ultimately winning on the merits because we haven't even talked about the merits yet. So, but in my own mind, as I'm trying to generate, what does a perfect case look like for both sides? I'm in a perfectly argued case, I think Katie might be able to pull this out. That has nothing to do with bias about Katie, because I don't know her, nor do I particularly want to. Just here's all the things, here's the defenses. I mean, I can do the analysis I can do the analysis for you off the back of my hand. I'll do the analysis for you just to show you why I think that's true. All right. So as far as I can see it, in my humble opinion, the principal issue in this case is defamation. There's some other stuff dealing with intentional infliction of emotional distress, which is a total loser. Negligent infliction of emotional distress, which may be civil harassment, and I think there might be something else. But the crux of this case, in my humble opinion, is the defamation. I think if the defamation goes away, I think the all goes away. I don't think anything else stands because of the way this is being done, the way this is being drafted. Excuse me, I have to message this person back real fast. I'm just, yeah, hold on. All right. Anyways, where was I? Okay, yeah. So I was setting it up. So the principal issue in this is defamation. All right. So here's Toddy's argument. Toddy says that Katie has said a whole bunch of things about her and James and the business, and these things are defamatory. Okay, fine. So what are our defenses look like for Katie? Well, first of all, we have some possibilities for underlying truth. Some of these statements appear to be true. Like, for example, saying that James was in default judgment that he was in default judgment relating to fraud in a business. That's true. That happened. We've seen the documents. It's objectively reality true. Unambiguously. James was, in fact, in default judgment, and as a result of that, he was adjudicated as being a fraudster with respect to a business. Now, that judgment was overturned at some later point, but that happened. It's objectively true, right? All right, so we have some ideas that some statements might just be objectively true. Then, of course, we have some ideas that some things are protected opinion, at least arguably. So, for example, here's an argument. I'm not saying this is correct. I'm saying here's an argument. One of the things that people are really upset about is the time that Katie Joy seemed to strongly imply that James took his own mother off life support for financial reasons, but for the money. All right, so the question might be, did he take her off life support? And that part seems to be true. The other part is for this reason. Is that an opinion or an effect? It's like, can you prove it or disprove it? I don't know. But you can at least make an argument over whether that's opinion or not. So, I don't know, but maybe. But at least you could argue it. All right. So you have some underlying truth, and then you might have protected opinion. If that doesn't work, then you're off to your next trick. Your next trick is to say that Toddy and James and the business are public persons. Toddy is clearly a public person. It's not even debatable. The business is clearly a public person. It's not even debatable. James is debatable. I think the better legal answer at this point is he is a public person. Now, what does it mean to be a public person? To be a public person means you're purposefully injecting yourself into the public sphere. Did James purposely inject himself? Yes. He appeared in multiple different videos from Toddy. Not just like passing through a video and not just like as a one-off. He seemed to be purposefully there. And more to the point, he was there to talk about makeup and things, which is the business. So he was there related to his business. So you can make a better than colorable case that he was there to promote his business and to advertise, right? So you can I think you got public figure status for Toddy without breaking a sweat. You get public figure status for the business without breaking a sweat. And I think you get public figure status for James with a sweat. I don't think it's a gimme, but I think you can get there. Okay, great. If they're public figures, then the next part of the analysis is that you have to show maliciousness. So it not only has to be false, it has to be malicious. And you're like, of course it was malicious because of these things. I'm like, no. Malicious this is a term of art. It has a particular meaning. The best way of phrasing it, in my opinion, is to say that what we mean by malice is malice to the truth, not to the person, but to the truth. That's the malice we're looking for. Yeah. So we're not interested in like whether or not there's hatred to the person or whether or not they dislike him or anything. We're interested in the malice to the truth. So to get to malice, we have to show the actual malice, we have to show that you know it's false or you recklessly disregard the truth. And that's pretty hard to get to. So then you're like, okay, did Katie Joy recklessly disregard the truth? No. Why? Because Toddy's own civil harassment claim undermines the defamation claim. Because their own civil harassment claim is, here's all the things they did of looking up all these records and pulling all this documents and stuff like that. And if I'm Katie, I'm like, yeah, correct. I did. I pulled documents. I pulled all these things from everywhere. You're right. I did so much research. So much research. How could I possibly be reckless to the truth? I did a deep dive. So very deep. In fact, you're complaining about how deep it is. That's how deep it went. All the deep. That's what she said. So, yeah, how could I possibly be reckless? So even if somehow I said something that wasn't true, I wasn't recklessly disregarding the truth. Right? Okay, then you say, all right, well, what if for some reason they're not public figure? All right, okay, what if they're not public figure? Okay, so let's assume the counterfactual. Let's assume they're not public figure. Okay. So let's assume that Toddy and James and the business are not public figures somehow. Okay, fine. Even if they're not public figures, we have to prove negligence. And my defense is exactly the same. Again, all the research. How negligent can we possibly be? How negligent can we possibly be? We did so much research to try to find out what's true and what's not true. So even if we screwed it up, how negligent could we possibly be? Right? So that's why I think Katie Joy, in a perfectly argued case, has a winnable argument. Now, there are arguments against all that. So I was just trying to make the point. So there are arguments against a lot of that. So I don't think it's a lost cause for Toddy. But if you're like, why do I think that Katie has a legally cognizable defense? Here's why. Here's what her legally cognizable defense is. Yes, I did all the research. Of course I did all the research. You're insane. Of course I did. I happily and cheerfully admit to how much research I did. How can I be reckless? How can I be negligent? So, underlying truth, protected opinion, public figure, actual malice, negligence. There's your case right there. So fun, And then once the defamation disappears, the IIAD is going to disappear for sure. That's going to disappear. The negligent infliction of emotional distress, again, one of the key words might be negligent, and you're just gonna ride that defamation. So you're just gonna say I was doing protected speech, and so that isn't negligent. Because again, I can't be negligent. So even I don't think the NID works. The civil harassment, it's like you can't have it both ways. I wasn't harassing you, I was just making videos about you, which I have a right to do, whether you want me to or not. And the whole case goes. Now, I think that by no stretch do I think that Toddy doesn't have an argument. I think Toddy has an argument. In fact, I think it's kind of close. I'd actually happily argue either side. I could argue Toddy's side too. But you guys are like, well, why do you think Katie has an argument? I'm like, here's why. Here's the legal analysis. And then you're like, but she's a bad person. She said some really horrible things. I don't know. I don't know what to tell you. Here's the law. Here's the legal analysis. She harms everyone everywhere she goes. She's nothing but a tornado of destruction. I don't know about any causes of action anyone else has, but, Multiple videos disparaging the business and individuals equal malice. No. Again, when we say malice, we don't mean malice to the person. We mean malice to the truth. The word malice is misleading. Malice has a special meaning in this context. By malice, what we mean is malice to the truth. Or to put it in formal legal language, because last time I did this, someone got super salty at me for saying malice to the truth, because they're like, that's not what the law is. I'm like, okay, you're right, it's not. It's just a very easy way to sum it up. But let's do this in formal legal parlance to make those people happy. To find defamation for public figure, we need to have actual malice. To have actual malice, you need to show that you knowingly disregarded the truth or that you recklessly disregarded it. Okay, congratulations. Now I put it in formal legal language. But yeah, no, that's not what malice means in the sentence. Do I think Katie should have submitted so many declarations? This whole thing is stupid. Yeah. JB has it right. She is X, she is Y, Z, super wow, W. None of this matters. Yeah, that's right. That's right. That's right. No one cares. No one cares about any of these things. No one cares. Let me tell you about how much no one cares. I care. No one cares. No one cares. Sorry. What do you say about career criminal? I don't even understand the question. Who's a career criminal? What? I don't know. What are you talking about? What you mean? Are you saying that Katie is a career criminal? Do I care? I don't care. I don't care. I can't. I don't. Doesn't matter. Why would it matter if Katie's a career criminal? Why does it matter? One issue at a time, man. One issue at a time. Why does it matter for their purposes? Why does it matter if she's a career criminal or not? How does it impact the legal analysis here? The question is defamation. Here's the standard for defamation. Here's the law. How is Katie being a career criminal either way? How is that relevant to any legal issue? It's not relevant. Who cares? No one cares. Karen called James a career criminal? Okay, well, again, there seems to be some evidence that might support that. Again, because we read the default judgment. James was in fact found in default judgment for fraud in a business. Now that was later overturned, but fraud is also a crime. So there was an adjudication of fraud that did exist at one point. So what does it mean to be a career criminal? And then depending on what else she knows and what else she's talking about, it might be true. I mean, career criminal can imply a whole bunch of things, but maybe it might be true. And even if not, it's not reckless to say it because there's evidence that would support that proposition because of the default judgment. So, I mean, Don't be a rude jerk. Am I being rude? Yeah, I don't know. I'm not the bad side. He just got mad at a question. Did I get mad at a question? I don't know if I got mad. Did I get mad? Sorry if I got mad. I'm just like, none of this matters. If you're Toddy's lawyers, how would I examine KJ and RJ? Oh my God. Well, I mean, first of all, that deposition is going to go on forever. And that deposition is going to go on forever because we're going to have to ask about every video and every statement. I mean, if I'm Toddy's lawyer, I just really have to find those statements that are... So if I'm Toddy's lawyer, I need to find the statements that are factually provable and for which reckless can get. But there's so much stuff that Katie says. Katie has said so many things, so many things, that I feel reasonably good if I'm Toddy's lawyer being able to do that. And I also feel reasonably good as Brown's lawyer. So I feel pretty good either way. She's reportedly said she's a journalist sharing facts. Okay. I mean, fair enough. Looking less tired? Yeah, I feel good today. I come off as easily frustrated? Yeah, I don't know about that, but fair enough. There's one video that says she forgot the truth and purposely stated things that were wrong. She says she purposefully stated things that were wrong? If she forgot the truth, then she wouldn't be able to purposefully state they're wrong. But if she's really purposefully saying things she knows to be wrong, then that would be actual malice. If she actually knows it's wrong and she's actually reporting it, even though she actually knows, that would be what actual malice is. So you're there. If you can prove that, then you're there. You've overcome even public figure for Toddy's lawyer. So if that's true, then Toddy's case looks a shit ton better. Does intent to defame matter? No. It doesn't relate around intent. No. It's negligence or recklessness. Intent is not the issue. In my opinion, Katie should not with this case in Minnesota. Can we talk about Minnesota Rule 405 and 406? What is Minnesota Rule 405. Is that a state level rule? Because when you say Minnesota Rule 405 and 406, those are state level rules, which wouldn't be a true. And this will be in federal court either way, I would imagine. So I don't think I don't think that Minnesota Rule 405 and 406 would apply off the top of my head. What about the assertions that he often his mom for money? Yeah, again, we covered that a little bit earlier, but half of that might be factually correct. That either James removed his mom from life support or he didn't, right? So either that's factually true or not. So did James remove the mother from life support? I think that's factually true, is based on my understanding. Now, what his motivation was behind that, is that fact or an opinion? That he was doing it for this reason as opposed to this reason? I don't know. I'd have to think about it, but it might be an opinion, because it's like you did X for Y. Is that an opinion or is that a fact? Can you prove it or not? Can you prove it either way? I don't know. It's a question. That's Federal Rule 405. Okay, let's take a look at Federal Rule 405. All right, let's take a look. Minnesota Rule 405. Let's see if we can find it. Federal court uses local procedural law? No. Let me look this up. Yeah. Okay, yeah, it's substantive, not procedural. Yeah, so I'm just trying to rewrite it just to see if I missed something. But Erie is substantive, not procedural. When a federal court encounters a state law issue, the federal court must honor the state law as to the substance. That's right. But not the procedure. It's like, did I massively misunderstand? Did I massively misunderstand? Yeah. Okay. Yeah. Did I massively misunderstand? Erie Doctrine. I mean, it's been a long time since it's come up, but I don't... Yeah. Yeah, so this is from Gasick versus American Airlines, 7th Circuit. Under the Erie Doctrine, federal courts in diversity cases and any other case in which state law supplies the rule of decision apply the state substantive law, but the federal procedural law. See, for example, Gasparini versus Center for Humanities, 518 U.S. 415. So no, under Erie, a federal court does not apply the state procedural law. So you misunderstand Erie. And one of the ways you know that, for example, is because the courts are still struggling with state anti-SLAPP law, which is, it's a mess. Is it too late for defense to ask to settle? No, it's not too late. Doesn't mean they have to say that's me. But thank you for making me double check, because I don't want to give someone bad information. It was alleged in the court documents that James did that. The court found it did not happen that way, but Katie said it anyway. I'd have to get into the specifics. I don't know. Yeah, I was wrong, not you. Okay, thanks. I wanted to double check, yeah. But thank you for admitting that you made a mistake, because I always like to admit when I made a mistake, so I appreciate that a lot. If she's reporting these things as facts rather than opinion, actually stating them are facts, will it change your opinion? It might. I mean, I'd have to get into it. I'd actually have to really get into it. So I'm not saying that I don't want to be understood as saying that I thought that they were opinions. I don't think I said that. And if I muddy the waters, then I'll just be clearer. I wasn't saying that they were opinions. I was just pointing out these are good arguments. And I even went to some length to say, this part is fact, but this part may or may not be opinion. Not quite sure. So I did express some doubt. I don't think at any point I said, yeah, this is absolutely a protected opinion. I was doubtful because I'm like, I'm not sure. It might be, it might not be. I'd have to actually really think about it. And I have to think about it more. I think I expressed enough doubt in there. So would it change my opinion? Yeah, it might, because I'm not sure what my opinion is yet. Hawaii court docs? What about Hawaii court docs? Yeah. I appreciate you looking things up to clarify for us non-lawyers and explaining. Yeah. So Erie is a very, very famous case. It's an extremely famous case. All you have to do is say Erie. You just have to say the word, and like every lawyer has flashbacks. But yeah, it stands for the proposition that when a federal court is interpreting state law, they apply the state law. So they defer to the substance of the state law, but not to the procedure. Yeah. So. If you've seen the videos, you'd understand our passion behind this. Yeah, which is probably a good reason for me not to see the videos, to be quite honest, or at least not at this point. You know, if I actually were doing this for real, I'd have to see them later. The court hasn't gone to view them now, and the court hasn't viewed them now because they're not material to the issue. But yeah, at some point I'd have to watch them, and I'd have to try to, you know, look at them in a dispassionate way, which sometimes can be hard. If KJ claims ignorance, is that not malicious and not defamation? No. If she says she's ignorant, you have to either have to know or recklessly disregard. So if you know that you don't know, the question is that reckless? Is that reckless? And reckless is a pretty hard standard. So saying you don't know means you're in category number 2. So then the question is, was that a reckless decision? Which it may not be, necessarily. Can KJ keep claiming ignorance after multiple cease and desist? Yes. Yes, because what Saltz says the facts are, she doesn't have to, like, accept them as true. I mean, because I could write you a letter and say, here are facts. It doesn't mean that you have to accept them as true. It might give you some knowledge that would require you to perhaps look more. But just because I send you a letter and say, here are facts, and stop misrepresenting the facts, doesn't mean that what I'm saying is true, nor the fact that you have to accept them, nor the fact that there might be other information on which you could rely. So, it might be a factor, but it might not be. So it kind of can go either way. Have I seen a case like this before? Not like this. This has gotten completely out of control. This has gone well off the rails of anything that makes any sense. Oh, thank you for the 1,046 of you who are here. And I really appreciate your questions. And I try to give you the best answers that I know how to give. And if you'd be so kind as to give this a like, if you haven't already, I'd really, really appreciate it. Yeah. Do I think courts will allow screenshots as evidence? Sure, why not? As long as it's authentic and they can agree to authenticity, then sure, of course, why not? Question, what if it's proven that KJ is mentally ill? It doesn't matter the way that the standard is written. It's written neutrally. Mentally ill people don't get to defame people that they want either. Ignorance of facts is different from ignorance of the law. Big time. Big time. Yeah. Ignorance of facts can absolutely be a legal defense. Yeah. So ignorance of facts can be a legal defense for sure. And I'll give you a scenario that could happen. Let's say that what's a good one? I'll just give you the simple one, even though it's not really great. But let's say that you go to a diner with an umbrella, and this diner has a place for everyone to put their umbrellas. So you put your umbrella in that place, you eat your meal, and then you take your umbrella and you walk out the door. But it wasn't your umbrella. It's someone else's umbrella. You didn't notice. So are you guilty? No. because you were mistaken as to a fact. You thought it was the umbrella, it was your umbrella, but not. But mistake of fact is absolutely a valid legal defense. Do I think YouTube is going to change their layout? There have been many lawsuits in regards to them just the past couple of years. Couldn't speak to that any more informatively than you could, to be quite honest. Brown says like he believes everything Katie has said without listening to her videos. I would be surprised if he's listened to too many of her videos at this point, because it's not necessary at this point in the case. Do we have any information on hacking? No, that information has not come out yet. Anything else? This case could get really intense, I think, when it gets to the merits, because they're going to really slog over every inch. And Katie's in a tough position. Katie's in a tough position, but she might be able to pull it out. All right, well, if that's all for now, then I'll just simply say thank you for the 1,000 people that joined me. If you're enjoying this content, please remember to hit the like button. Helps the channel grow. Please remember to subscribe, and you too can become a member if you like for 99 cents. Hit the button and become a member of the channel today. I hope this has been informative. We'll look forward to Saltz's next filing on this and see if we get any more information about what Saltz was thinking and try to adjudicate that. Until later, my friends, cheers and goodbye.